I'm really fortunate to be here today with lawyer Michael Waite QC, a hospital defense lawyer from Carbert Waite LLP in Calgary. This podcast has been a long time in the making. Mike and I first connected about doing a podcast in December of 2019. It is currently the end of November 2020, so we are almost 1 year into it. When I first contacted him, he was just busy with his work, and we took some time to talk about the podcast. And before we could even schedule a time to do it, COVID-19 hit, and his role as a hospital defense lawyer made him a little tiny bit busy. I looked back at some emails from him a couple of days ago, emails I received during that time, and he describes himself as swamped and drowning and crazy and underwater. And so we put it off for a while. I contacted him again in April, but COVID had not let up in the way that we thought it would. We talked again in August, booked a time for October. And then in October, Mike's son was diagnosed positive with COVID. So we canceled that time. That was booked October 18th, and we just let things simmer for a little while. And luckily, here we are today, almost 1 year after we started planning this. And on the morning after, Alberta has just not declared a state of public health emergency and a circuit breaker lockdown that's going to start about 48 hours from now. So I just feel really lucky to be here. Before I start talking to Mike, I'd like to fill everybody in a little bit about Mike. I've known him for several years because through my own work as a nurse, I was aware of who he was and what position he played in the healthcare region where I worked. And I've invited him to speak at some of my conferences. He's a great speaker. He's such a strong presenter. He's so knowledgeable. And he's also got one of the best voices I've ever heard. And I've told him this so many times. He's so listenable and has just one of those fantastic radio voices which you could listen to all day. But anyway, enough about that. Let me tell you a little bit more about Mike. He began his legal career with Bennett Jones and then joined Carbert Waite in 2003. In 2020, he was appointed Queen's Counsel, which is the QC after his name, which is only awarded to lawyers who've made significant contributions to the legal profession and demonstrated exceptional leadership. His litigation practice is incredibly varied. He represents healthcare institutions, physicians, and all the employees, such as nurses who work for healthcare institutions, on a wide range of complex issues. He's a very experienced employment lawyer, advising employers and employees on issues around disability, employment, and human rights. He has extensive experience in estate litigation, commercial litigation, and civil fraud. He's appeared before all levels of court in Alberta, in the Federal Court of Canada, as well as the Alberta Human Rights Commission. He's most significantly known and loves, and most of his work is in serious personal injury and medical malpractice. And so our paths have crossed several times over the last 15 or 20 years. But he's also had the privilege of acting roughly equally for both plaintiffs and defendants, which brings a very balanced and practical approach to the law. And you'll find that as you listen, that he's got a very open, fair look at both sides of the story. He's very skilled at diffusing tension and emotional barriers. On his awards and service to the community, he's been recognized in Canadian Legal Expert Directory every year since 2015. He's been recognized as the best lawyer for his work in estates and trust. He received the prestigious University of Calgary Faculty of Law Honorable W.K. Moore Award for contribution to law. In 2007, he was named one of Calgary's top 40 under 40, recognized for his legal work. He's taught health law as an adjunct professor at the University of Calgary. He's been on the board of directors of Legal Aid, vice chair of the board of Hospice Calgary, member of the national executive of the Canadian Bar Association Health Law Section. And there's a lot more that I could say about him, but I think that's pretty good to kind of set the stage for what an impressive lawyer he is. So let's get underway. Welcome, Mike. Thank you so much for being here today.
Thanks for having me.
It's really a pleasure. I'd first of all like to hear your own personal journey and story with COVID-19 experience. You're honestly the first person I've talked to face-to-face who's gone through this. Can you tell us the whole story from start to finish?
Sure. I didn't personally have COVID, but one of my sons, who's 12, was diagnosed as positive, and it was one of those situations where we had no expectation that he was going to be positive. He had basically a cold. He and I had gone golfing, played 9 holes, and shared a water bottle, and he came down that night with a little bit of a sore throat. And so we kept him home from school and booked the test. This was early October 2020, and it took a while to get the test, so a little over 48 hours to get in for the test, and then it was 3 days before we got the result. And by that time, he had essentially recovered, and I had started coming down with cold symptoms. The symptoms I had were a little bit worse than he had, so cough, runny nose, stuffy, that kind of thing. But none of the sort of classic COVID symptoms, no loss of sense or smell, no nausea, vomiting, anything like that. And so it was a big shock to us that he tested positive, and we had all then gone for tests, and so my wife and my older son and I, and so another 3 or 4 days later, we got our test results, and they were all negative. And I sort of didn't believe it because I felt because he and I had the same symptoms, either he was positive. If he was positive, I was positive. So I went and got a subsequent test and was negative again. So at the end of the day, I think we felt that he was false positive, but we did all the right things. So as soon as we got the test result, we went back through our calendar and figured out who we'd been in touch with, and we contact traced ourselves, essentially, let everybody know and let the school know. And so then the school kept his whole class home for a week. And but because he was already sort of 6 days in by that time, they only had to do another week. So the whole class was out of school for that week. And it was an interesting journey for him because, I think he handled it really well, but I don't think he was really happy about being the cause of everybody having to be home and kids talking about it and that kind of thing. But at the end of the day, he was fine, I was fine, no one else got anything, and my wife has leukemia, and one of the concerns we had is if any of us get sick, what kind of impact that would have on her. But she's been fine, and so we just continue to do what we do. It was interesting though, because we had been super careful for so long. When this happened in March, when the kids were taken out of school, we moved to BC. We have a condo in Mara Lake. And so we moved there and basically didn't see anyone certainly inside our condo for months. And we spent time outside, and we just spent time as a family, and really isolated ourselves pretty well. So when we came back in September, it was a bit of a shock to the system to come back to Calgary, because it was a very different vibe. But, we had felt like we had, done all the right things. And then 2.5 weeks into school, he ends up testing positive. So, I think at the end of the day, it's a good news story. Everybody's fine. But I ended up having to isolate for 3 weeks myself because we assumed I had it. He and I shared a bathroom. Everyone else sort of isolated elsewhere in the house. And so AHS told me that I would have to isolate for 2 more weeks after his last day of potentially infectiousness. So that wasn't fun, not being able to leave my property or leave the house for 3 weeks. When I went to get my second COVID test, I felt like it was freedom. I got to go out in my car and actually go, and I was so happy to go get something shoved up my nose in the COVID test. That was sort of my excitement for about 3 weeks. But
that's kind of sad, Mike, isn't it?
It's really quite sad, but that was my excitement. So
yeah,
I feel for people who actually have it and are sick and have to isolate much longer. We were lucky.
Has the experience changed your approach or your fear or lack of fear about COVID?
Not really, because I think we were already pretty cautious because of Shelley's diagnosis and just wanting to make sure we're as safe as possible. So, I've been pretty careful with, mask wearing, and as I'm the managing partner of our firm, and we've taken a pretty cautious approach as far as the numbers of people that attend the office at any given time. And we instituted mask wearing in our office quite a few weeks ago, and those kinds of things, just to make sure we're doing what we can. But I did actually attend the hospital myself because I started feeling a little short of breath. And frankly, I think it was probably anxiety as much as anything.
Yeah.
That was the day that he got the positive test, and it was probably just cold symptoms, but I just felt a little short of breath, and I wanted to go to the ER just to get my pulse or my O2 sat checked.
Yep. Smart.
And doing what I do for a living, it's a little knowledge is a dangerous thing, and I think you can become a bit of a hypochondriac. So I wanted to get that checked, and it was low normal, and so I got some tests done, and everything was fine. But just being in the ER at the Foothills, in this sort of COVID pen that they had, so the people that are potentially positive or in there for suspicion of COVID, we're in a very small area in the ER waiting room, and there's literally orange construction kind of gates to keep us in that one spot. And it was I was there for, I don't know, maybe 4 hours or something like that. Everybody was great. The healthcare, they're doing the best they can, but it was an experience.
Yeah, these are interesting times. There's no doubt about it. Well, I wish you continued health for you and your whole family, for your wife, Shelley. I hope her journey goes well as well. It goes well as well. And thanks for sharing that. I've heard of people who had it, but I have never spoken to anybody who's been quite this close to it, whether your son had it or not, I guess. But it's been interesting for all of us. And here we are today. We're filming this Sunday, late November, the morning after Alberta has declared a public state of emergency. So we're just all heading into some version of lockdown again. But anyway, let's move on to something else, because we're not here to talk all about COVID. I just wanted to hear your story. In the past, we've talked to plaintiff lawyers who've really talked about their role in medical malpractice lawsuits. And I've known you for quite a few years, and you're very pragmatic, I've always found, about your job and your position and what your specific role in is, what you do. So I would really appreciate explaining to all of us what happens, specifically talk about your role as a hospital defense lawyer, and what happens, how does a lawsuit come to be in your world from the first moment you hear about it until it goes to completion?
Well, I'll take the first part first, which is the role of the hospital defense counsel. I think different people have different views about our role and on the defense side in medical malpractice cases, and I'm sure there are plaintiffs' counsel out there who have views about the role we play that may not be as positive as the views that I have of the role we play. But at the end of the day, what I think is that, our role is to protect the professional reputations of the health providers that we represent. And that means something, right? That the fact of the matter is most people come to the healthcare system with a pre-existing problem that they're asking for help with. And often there's unfortunate outcomes. And very often that has nothing to do with anything that it was done or not done by the health providers involved. And it's just an unfortunate adverse outcome. And I think what's important to me is ensuring that the health providers get the support and a proper defense, so that if they met the standard of care and they did everything that they should have done, and it's just an adverse outcome, they shouldn't be held responsible for that. On the other hand, if there is a problem, I'm a firm believer in resolving cases where there has been an issue with care provided, and that issue potentially caused harm to the patient. It may not be the full harm that plaintiff's counsel thinks it is, but I believe that cases that should be settled, and they should be settled as soon as reasonably possible. It's important, I think, for the integrity of our system that people get compensation if they've been injured. But I think it's also important that the system be defended, that it cannot be an insurer for positive outcomes, that every time somebody comes to the healthcare system and something goes wrong, that somehow the person gets compensation, even if it wasn't the result of anyone's substandard care. So that's my perspective on sort of what the role is of a defense counsel.
I'll just interject something there quickly. I love how you just said it can't be the insurer of healthy outcomes, or that's a really great way to say, because working in healthcare my entire career, I know that to be the truth, that things don't always go as they should. But, I've worked with a lot of lawyers across the country, and I think, the word on the street is that you are as fair as you just described, that you're reasonable and you're fair to work with, and you understand your role very, very well. So congratulations on that. You've achieved that.
Well, thank you. That's good to hear. Because I think it is important to a large extent on the defense side. We're funded by taxpayers, right. And I take that seriously. We're stewards of the public system, and sometimes that means a vigorous defense through to trial because we feel that the care provided was defensible, notwithstanding the adverse outcome. And sometimes that means resolution of cases. But on sort of how things come about, for us, generally speaking, a health region or a hospital or a care home, whoever it is we happen to represent, will get served with a statement of claim. And sometimes that involves individual defendants who we will also represent. So we don't generally defend physicians, although sometimes we do. Most of the time they're represented by counsel for the Canadian Medical Protective Association.
What are the situations where you would defend physicians?
Essentially, it's in circumstances where there was no CMPA membership at the time of the incident. Those situations are becoming more rare. Where we would see them in the past would be international medical graduates who came in under, there's a variety of ways they can come in and provide services within the hospitals, and sometimes they didn't get CMPA coverage. And so in those circumstances, I would be involved in representing them. Actually, the last medical malpractice trial I ran was on behalf of a resident international medical graduate who didn't have CMPA coverage. Really? So it happens, but it's happening more and more rarely going forward. So most of the time we're representing nurses. That's our biggest cohort, but it would also be respiratory therapists, occupational therapists, physiotherapists, those kinds of things.
They just get sued less frequently than nurses and doctors, is that correct?
Right. Yeah, nurses get sued less frequently than doctors, and it kind of goes down the chain of the other health disciplines that I mentioned. And so, the region or the hospital or the care home or whoever gets served, it gets provided to I'll call it an insurer. It's not necessarily a traditional insurer, but it's a reciprocal defense organization. And then that gets forwarded to us, and we then start taking steps to do an investigation and let plaintiff's counsel know that we're on and that we're representing whoever are employees of the organization.
And could I just ask, is that when the statement of claim gets forwarded to you, is that typically or always a surprise? Or do you sometimes or often have a heads up that something's happened that might end up in a malpractice case?
Yeah, it's a good question. So there's, and this has changed over time, and I think the hospitals and health regions and care homes have all gotten better about being proactive when incidents occur that they think might involve litigation. They'll give their insurer, for lack of a better term, the heads up, and sometimes an investigation will be done, whether that's an internal investigation. Sometimes legal counsel will be engaged to do an investigation. Most of the time, though, for us, because we're external legal counsel, the facts are new to us. It's not very often that we would be aware of an incident unless we were retained to actually do our own investigation earlier on. And so then we're starting from square one. If there's nurses that have been named, we will reach out to them, talk to them, get their story, gather the health records, prepare a defense, and go from there.
And I want to talk about the go from there part in a minute, but how does that phone call go, or that first contact with nurses? I mean, I know from being a nurse myself and talking to thousands of nurses that the fear of being sued is real and big. And how does that conversation go with them when you contact a nurse and say you've been named as a defendant in a lawsuit, or named in a lawsuit? I don't want to butcher the language, but what's the reaction of most nurses when you call them and say that?
Yeah, the benefit for us is, and this is a practice that we've developed with our internal counterparts at the various health organizations or care homes. Generally speaking, someone internally has made that first phone call. So they would have contacted the nurse already, sort of talked to them about the circumstance. And
internal meaning like a charge nurse or a supervisor or a hospital representative of some sort?
Right, or internal legal counsel. Like if the organization has a legal department, often that person will make the initial phone call.
Got it.
Or they'll engage, as you say, the supervisor, patient care manager, somebody like that to make the first phone call. It's important for the person to hear it from somebody they trust first and not some outside lawyer. So that is generally what happens. We're usually not the first call, although sometimes we are, just simply because the nurse will get served individually. So sometimes, like, the hospital will become aware of the statement of claim because they're served at their registered office. Sometimes the plaintiff's counsel will send out process servers and they'll find these nurses either at the hospital or at their homes or whatever. And so sometimes we're the first one to have that conversation. And it often doesn't go well from the nurse's perspective. They're upset.
Right.
They're worried. And so we spend quite a bit of time at the beginning just trying to educate them, make them understand that not only the insurance, but also their employer will stand behind them and is responsible for their actions as long as those actions were in the course of their employment. And most nurses are able to sort of reconcile and understand the role that they have to play in the legal system, but it takes some time, and some people are more chill about it, if you will, than others. One of the things that I do, I sort of have a spiel that I give nurses, and I talk to them about their professional obligations. That if we're talking about registered nurses, they're a regulated health profession. They were providing care as part of their professional obligations, and part of their professional obligation is to assist the court, the plaintiffs, and the defense in a lawsuit to find out the facts. And, there's lots of privileges we have as professionals. This is one of the downsides, I guess, if you want to call it that, where you just have an obligation to do your duty to the court system and the justice system and to the plaintiff. They were your patient. You're obligated to assist them and provide your information to them. And for many people, that will sort of resonate in that, wait a minute, this isn't as personal to me. This is about my role in a bigger system. Some people, it doesn't necessarily resonate, but I give it a try anyway.
Yeah, good. Because I think you just hit the nail on the head that it is very, very personal for some people that, and I think there's so much misunderstanding about what you just described as the professional's role in the legal system and their duty to the courts and the responsibility within their profession. Because, I think many nurses and doctors that I've spoken to take it very, very personally. It's a shameful moment in their life that they've made a mistake that may have harmed someone. It's interesting. I just did a podcast with Dr. Danielle Ofrey, an internist at Bellevue Hospital, and she talked at length about that, the emotions of doctors and why lawyers should care about the shame that they're feeling and approach it as shame versus belligerence or anger or anything else that you're sometimes met with. But I want to step back just a little bit, because I think so many nurses I've talked to have so little knowledge about how this whole process goes and their role in it. So I appreciate that you take the time to explain that to them. But when you said you call the nurse and you get the medical records and you give them an opportunity to tell their side of the story, what does that look like? Like, what information is the nurse given? What is she able to review? Well, first of all, how many nurses remember the incident that you call them or that you talk to them about? Or is it just fresh news to them?
It's a good question. And the typical legal answer is it depends. I think it depends on a few things. One, how traumatic the incident was itself. So if it was an obstetrical case where the baby came out and there was a resuscitation and it was a very, very difficult traumatic thing, it's much more likely that the nurses directly involved in that will have a recollection and will remember. And that's in some ways easier for them, in some ways harder for them. Nurses who were involved earlier in the day or perhaps the shift before, who just covered a break, most often they don't have any recollection of the patient at all because they weren't there when the traumatic thing happened. And it also depends on how long it takes for plaintiff's counsel to serve the claim. So depending on the nature of the case, it can be sort of 3 years from the time of the incident before the nurse or anyone within the system is aware that there's a lawsuit. In the context of a child, it can be 20 years. And we've actually seen a number of cases more recently where plaintiff's counsel have not served the claim for at least 10 years. And that makes it very difficult. Obviously, all of our memories fade over time. And so when it's that far in the past, it's not just memories that fade, but then it's issues about, well, what policies and procedures were in place at the time? What was the standard of care then? Because it's certainly not what the standard of care is today. And I think that's a part where sometimes plaintiff's counsel can get tripped up by attempting to sort of enforce upon a nurse from 2008 the standard of care from 2020, right? And, the courts are very clear that the standard of care is, the only relevant standard of care is the standard of care that existed at the time of the incident. And so, I think proportionally, less than half of the nurses that we see would have any memory at all. And then the other half would have anywhere between a little bit of memory to it's sort of burned in their memory. And I think it just depends on the circumstances.
Right. And what about when you said you talk to them, you let them know about the lawsuit and talk about their care and review the facts of the case, or however you said it? What information is given to a nurse? Like, do you pull the medical record and the nurse sits down and looks at the documentation in the record to jog his or her memory? What do they get to recall the facts of the case?
That's our practice. So they'll get the statement of claim, and we always say to them, read it, but take it with a grain of salt, because that is just the sort of the best case scenario for plaintiff's counsel based on limited information, right? Plaintiff's counsel are drafting that statement of claim based on presumably a review of the chart, but not much else. And so they don't have all the facts when they do that. Then they get the selected portions of the records. So our practice is to provide them with records for the time period that they were caring for the patient.
Right.
What I don't want is a situation where nurses, because they often are very keen and they want to sort of look at everything, I don't want the nurse to have all of the records from beginning to end, because it can potentially pollute their memory as far as what they actually knew at the time and what they know now. So I try to just give them what's relevant to them. What was their charting? What was the circumstances on the shift that they were working that day?
And so let's talk just for a second about nursing documentation, because I've reviewed a lot of medical records in my lifetime in a lot of different capacities. And documentation in the medical record has been enough of a thing for me that I've written a lot about it, and am currently developing an online course about it with a lot of input from other people. But how important is it? How important is the documentation to triggering the nurse's memory and defending the care that they've provided in a lawsuit?
I think it's very important. I think that, obviously when something is being litigated years after the fact, it is very important to have as much relevant documentation, contemporaneous documentation as you can. And it does help jog memories in those circumstances that are in that sort of middle ground where the nurse may not have a great memory of the event, but when they actually look at the chart, some things can cause memories to be stirred. But I think, one thing that's always been a bit of a beef of mine, for lack of a better term, is this idea that if it's not charted, it's not done. And I know that, so nursing teachers in nursing schools will teach that. There have been some cases that have said versions of that. The more recent cases, I think, have criticized that idea. Because if you spend any time in a hospital, which you've done obviously over your career, there is no way for nurses or doctors or any other healthcare provider to chart everything, every single thing that they do. You hope that they chart the important things. You hope that they document what's required for patient safety and future patient care. But they can't possibly care for a patient and chart as if they're going to get sued, right? Because you wouldn't do anything else but then write in the chart all the things that happened and everything that everyone said and all of that. So, we rely on standard practice a lot, and it's important. And that's stuff that's not charted. But that the nurses did it because that's their practice. And so I think it's documentation is important. I do seminars, I'm sure like you do, with nurses to try to press upon them the importance of getting the really relevant material facts down on the chart.
Right.
But it's not the end all and be all. It can't be.
So how do you get around, going back to a Supreme Court of Canada decision, Counsel versus Jeffrey, which goes back to 78 or 9 or 80, where that exact phrase came from, I believe. If it wasn't charted, it wasn't done. How do you get around that as a defense lawyer? Or is it just what you told me, what you'd offer up? A lot of what's done isn't charted. And how do you impress upon nurses, I guess, is the other part of that question, that they don't have to document everything, but they have to document the important stuff. When there's a change in condition or a change in vital signs or something out of the ordinary happens. How do you impress upon them the importance of that?
Yeah, so, I think the case law has evolved, and there are a few more recent cases where the courts have criticized that not charted, not done thing, and because of the practical reality that I just described. And so when it has come up in our cases, we've made that pitch to the trial judges and said, this is just not realistic. Right. And generally the courts have been accepting of that, with some exceptions. But I think, in my view, where the courts have sort of held to that not charted, not done thing, it's because they were already going in that direction anyway. There's other reasons why they felt that the care wasn't provided properly, or things that was being said at trial that had been done, the court may have been convinced weren't in fact done for other reasons. So I think you can't read too much into it. Every case turns on its own facts. And I just think the courts have to be open to the idea that health providers can't possibly chart everything they do. Getting back to your question about how I sort of impress that upon nurses, is what I focus on is, what's important at the time. You have to use your clinical judgment. You can't be thinking of a lawsuit as you're providing patient care and documenting in the chart. But make sure that, the critical positive findings and the important negative findings are documented on the chart, and ensure that other important conversations, to the extent they can be documented, whether that's a documentation of a conversation between a nurse and a physician and the patient, or a nurse and the patient. And again, not every one of those conversations can be had, but in the context of an obstetrical case, documenting a conversation about whether a C-section should happen, for example, is something that I think is important, and nurses should try to get down on the chart. So, that's the problem. So much of this is about professional judgment, and nurses develop practices over time. And so what I tell nurses is develop a practice and stick to it, because it can save you at a trial where you can say with a straight face in a compelling way to a judge, I know that I would have done this. I know I palpate the abdomen when I check contractions in an obstetrical case, because that's what I always do.
Right.
I don't chart it, but I know that I did that.
But I do it. Some nurses ask me, if you could chart too much. And I don't know that there is such a thing, other than it takes away a tremendous amount of time from direct patient care if you're spending so much time charting. But I reviewed an obstetrical case a couple of years ago, and the care that nurse provided was awe-inspiring. I mean, what she documented about position changes and ice chips and warm blankets and back rubs and clean gowns. And she was so meticulous with her description of the fetal monitor tracing. I just felt like I could have drawn it myself based on her writing. But the issue was that there was signs of fetal struggle overnight. And, on a 12-hour shift, there were 6 full pages of progress notes, handwritten progress notes, but not a single word in there was that she'd notified the doctor. And at the end of the day, it came out that there was cultural issues on this particular unit, and this doctor just didn't want to be called until it was time for delivery, and that's what it was. And it was a night shift. So that was one of the cases where I thought, I've never told anyone you can document too much, but what you just said, you have to document the important clinical information, or all that documentation is going to convince anybody that you did what needed to be done in the situation. So,
what I would say to that, just to add, is that I think by documenting too much like that, they're not necessarily irrelevant things, but like overly detailed charting can actually potentially be a problem for the health provider, because I've heard judges say, well, their notes were so good, there's all this information in there, but there isn't this one thing, so therefore it mustn't have happened because she documented everything else.
Oh, that's a good point.
So it can be held against you, right? If you chart too much detail about things that aren't really that important.
Oh, good point.
So it's a balance.
Yeah, that's a really good point. If it looks like you document everything and you don't document that one thing that needed done. So let's take a couple steps back, because you got to the point in a lawsuit where you said the statement of claim comes to you, you contact the nurse and or perhaps a representative in the hospital, however that goes, and the nurse reviews the case details, and you said, and then we take it from there. And what happens from that point forward? So the nurse has reviewed it, statement of claim's been filed, you respond with a statement of defense, I'm assuming, and then what follows after that?
Yeah, before we file the statement of defense, assuming there are nurses who are defendants or other health providers who are defendants, we meet with them and talk to them. And the first part of that meeting is always about what I talked about before, the legal process, what to expect, how they're protected, and that, their house isn't at risk. And, because I've been asked that question, like, am I going to lose my house?
Absolutely.
So I always, with everyone, I deal with that up front, just to try to allay some of the concerns that they may have. And then I get as much information out of them as I can about the clinical situation, whether they have a memory or not, because what I do want to know, what is their standard practice? I do want to know things like you mentioned, are there cultural issues on the unit, or are there any other issues? So I, interview them in a fairly detailed way at or around the time we file their statement of defense. So obviously they get a chance to review their defense before it gets filed. So that's done. Then the nurses themselves aren't involved very much until the next phase of questioning. We have to then go do our document production. So all of the documents in the possession of the health organization, the hospital, whatever, will get produced in an affidavit of records. And then the next big step is the questioning phase. And so normally plaintiffs go first. So they're questioning the defendants, doctors and nurses or whoever. And so we spend time with them, meeting with them again, preparing them. What's questioning going to be like? We talk a bit about the personality of the particular plaintiff's lawyer, because we know the vast majority of them well. and just try to get them to the point where they're as comfortable as possible, so the nerves and the anxiety don't get in the way of them providing good evidence. And because it's important for them to be able to defend themselves and give their evidence and provide the facts and provide their justifications for what they did or didn't do. And sometimes the emotions can get in the way of that. So we do everything we can to make them as calm as possible. At the end of the day, I always tell nurses, you're going to be nervous. I would be nervous if you weren't, right? I would be scared of a nurse who walked in there saying, oh, it's fine. I'm not worried about this at all.
Right.
And so we spend quite a bit of time with them on that. All the defendants are questioned, and then it's our turn later on to question the plaintiffs, which is a different exercise. Most of the time, I mean, it depends on the case. Most of the time, the plaintiffs don't have a great recollection of everything that happened. Sometimes they do, and sometimes it's critically important. But from the perspective of the hospital defense or the nurses, the kinds of interactions that are really important with the plaintiffs aren't as important for nurses. So they don't have detailed informed consent discussions, for example. So then we do our questioning of the plaintiffs, focus on liability issues, what their recollection is, what their journey has been. And then we also have to, of course, go into the damages side of it. What impact has this had on them? Has it impacted their employment and all of that? And, that takes time to get through all of that. And we've spoken to experts prior to that point in the vast majority of cases to get a sense of whether we feel the case is defensible or not. But we don't really engage the experts in a detailed way until after questioning, because the questioning transcript is a very important part of the case. And then after that, it depends on whether the case is defensible and whether the plaintiffs are intent on pursuing it. We either resolve it or set a trial date.
How many of these cases go to trial in your experience?
More cases against physicians go to trial than against hospitals, because the reality is most good plaintiffs' counsel know that, in not every case for sure, but in many cases, they're either going to win or lose their case against the physicians because they're the primary health provider. And so sometimes hospitals aren't sued at all, even in circumstances where the alleged negligence may have occurred at a hospital. Or sometimes they're just sued, frankly, to get a copy of the health records and go along for the ride for a while, and then ultimately are let out.
Right. I've heard that.
Yeah. So, hospitals don't go to trial as often. And it's for those reasons, partially because we generally have less exposure, but also we're not as much a target as physicians might be. So in medical malpractice cases generally, it's a higher percentage go to trial than in probably any other type of civil litigation.
Really?
Because cases are not settled for economic reasons. The CMPA will not settle a case simply because it makes economic sense to do so, and neither will our clients. There has to be a justification on the basis of a breach of the standard of care before we're going to consider settlement.
Right.
And sometimes that's hard for people to understand, and some plaintiffs' counsel who don't do a lot of this work, it's a bit of a shock to their system when a case that they think could be resolved very reasonably financially is defended through to trial because it's defensible. And that's part of what I said earlier about professional reputations being on the line. And it would be irresponsible, I think, for us to, just because it's cheaper to settle a case where the standard of care was met.
Yeah, of course. How often does it happen that a physician is sued and the physicians, I don't know if this is the right word, but countersue or pull the nurses into the case, or vice versa? I've heard that the physicians will say, I didn't do this by myself, or I didn't know that was going on. There's nursing issues here. How frequently does that happen, and how does that play out?
I think it varies across the country. There are different relationships between physician counsel and hospital counsel in the various provinces. Some more amicable and some more adversarial. I can just speak to our practice in Alberta. Generally speaking, while we are adverse in interest, and that's, the people who I represent have different interests and different legal exposure than the physicians who are represented by other law firms. Generally speaking, there's, we don't question each other's witnesses, and there isn't a sort of open battle between the defendants in Alberta. Our view is that we each have a case to defend against the plaintiffs, and we'll defend that case. And we're not going to assist or hinder any other party in the litigation when it comes to their case.
Are you, though, technically the physician in nursing defense, on the same side, and I'm going to put that in quotation marks, in opposition to the plaintiff? Is there, I like how you just said there, we're not going to assist, or what was the other word? Assist or hinder the case by the other side. But is it like you two against the plaintiff, the physician in nursing defense against the plaintiff?
I think some plaintiffs' counsel would see it that way, but I don't, because of what I said earlier. I have a case to defend, and my case is very different than the case that the physician's counsel has to defend. The standard of care is different, the interactions are different, the care provided is different. So, I view it as, if the plaintiffs are going to name the hospital or nurses or other employees of the system, then they've got to prove their case against those individuals. And if they're going to name physicians, they got to prove their case against the physicians. And I don't see it as a 2 against 1 situation. I see it as essentially separate cases, and they both have to be met if they want to get compensation from both sides.
Right. Okay, good. Well, that's why I've heard it a little bit from plaintiff's counsel that, that it feels like a David and Goliath situation, certainly against the CMPA, and that's not my opinion. That's just what's been said out there. How long would it typically take a nursing negligence lawsuit to work its way through from the moment you hear about it until settlement or trial or it's dropped?
Yeah, it varies significantly, but if I had to sort of put a number on an average, I would say probably around 5 or 6 years would be an average. We have cases that are much longer than that. And, the more serious the case is, the more likely it is to take longer. The simpler the case, the more likely it is to be shorter. And there are some cases that I mentioned before where we probably shouldn't have been named, but plaintiff's counsel were just being cautious. So circumstances, for example, a surgical case where there's a clear question. The question is whether there was a surgical mishap by a physician.
Right.
There's really not much point in the hospital being involved in that case, but sometimes we're involved just to see if the circulating nurse or the scrub nurse had any recollection about what happened and that kind of thing. But often, once questioning's done, we get let out. But it can take a long time. We just settled a case, I think last year, the year before, that was 20 years. That it took that long, and that was I'll declare my bias, mostly as a result of inaction on the part of the plaintiff's lawyer, and there was 3 different plaintiff's lawyers over the years on that one. But it sometimes for good reasons, sometimes for not so good reasons, it can take a long time.
And is there any mechanism at play or in place to hustle that along in the courts?
Yeah, the defense certainly tries. So there are rules of court that allow us to bring an application to dismiss a case entirely if there's too much delay.
Right.
So if there's been essentially nothing that's happened in 3 years, there's a provision in the rules of court that allow the court to just dismiss it. And so good plaintiff's counsel diarize their files and make sure they do something at least every 3 years. The good ones, though,
seems like a long time.
It is a long
doesn't
time.
It? 3 years.
It is a long time. And most good plaintiff's counsel in medical malpractice cases, it's not an issue. Right. There's something happening. It's just there are the occasional case that for one reason or another just ends up dragging on much longer than it should.
Yeah.
But we do push. So we bring applications to compel answers to undertakings or move things along or threaten delay applications or whatever, just to try to bring it to resolution, because the health professionals involved deserve peace. Right?
Yes.
They shouldn't have this hanging over their head for 15 years or 10 years.
And the plaintiffs, right? The plaintiff and their families, I think. Well, that explains a couple things to me, because certainly as, I've acted as an expert in cases for both plaintiff and defense, and every once in a while there's a long period. Like, in fact, just last week I submitted an opinion in 2016, and all of a sudden just last week there's a whole flurry of activity and lots of other expert opinions to respond to, and lots of action. And I was like, where did this come from? I hardly remember the case, and I don't know. So it's interesting to hear that that's what's going on. That's what's going on behind the scenes.
I think there is if I can add, one of the issues that's certainly been a bigger issue more recently and in light of COVID is also court delays, right? Yes. So the way the rules of court are structured, we're supposed to basically be completely ready. So all of our expert reports, all the questioning is done and everything. And then we can ask the court for a trial date. In a complicated case that would require a trial of 3 weeks or more, we're now booking, I don't know exactly today what it would be, but it's probably 2023, 2024 to get the trial date. And so you have the situation where there's probably been some delay getting there, and then you have like potentially a 2, 3, 4 year wait just to get a trial date. And so, that's something that obviously the government and everybody's working on to try to get that time frame down. And that's certainly not by any means the biggest source of delay in med mal cases, but it is one factor. And I agree with you, your comment about plaintiffs deserving their piece as well. Like, I did some plaintiffs work earlier in my career in not in medical malpractice cases, but in personal injury cases. And I always felt that it's important to move the cases along in one way or the other. If the case is not going to be successful, then end it.
Right.
Or move it fast enough that you can get some sort of a resolution and let people go on with their lives.
Yeah, that's good. You just mentioned something about COVID and how it's going to change the court system, and I've heard that from across the country. In fact, a doctor I knew is just scheduled to go to trial in December, and that particular trial, which was already booked, has now been rebooked for 2.5 years from today. So I think this is going to mess up the court system. But in your opinion, do you see that COVID is going to change your job at all? The healthcare system, the delivery of healthcare, the lawsuits within healthcare? Any comments on that?
Well, I think it certainly had an impact in the short term on the healthcare system and delivery of healthcare, and you know more about that than I do. But as it interfaces with the legal system, I think there are some things that by necessity we've had to change. So in March, when everybody was really concerned about this and the healthcare system was making all kinds of changes to have surge capacity available for regular beds and ICU beds, it was pretty much made clear to us that unless it's an emergency, don't bug us, right? So don't be asking our corporate representatives for the hospitals or health regions to be doing tasks or trying to get documents for us, those kinds of things. Like, basically leave us alone while we get organized. And so that put a bit of a pause on things. The court system essentially shut down because of, people didn't want to have in-person questionings, so questionings were adjourned. That all happened in sort of April, May, June. And then when things kind of calmed down a bit and people started thinking, oh, okay, well, maybe this isn't going to be so bad, really June, July, we started ramping up again, started thinking about booking more questionings. And so a lot of my questionings that had been booked in the spring were moved into the fall. So this fall has been very busy. But what we also did is we started doing a lot more remote. And so I was a dinosaur. I wasn't wild about the idea of doing a questioning by Zoom or WebEx or whatever. I like the face-to-face interaction, reading body language, those kinds of things. And so I resisted for a while, but reality came crashing down, and I realized if I want to move my cases along, I'm going to have to be more open to doing questioning by video conference. And I've done quite a few now, and it can work. It can be clunky. It can be difficult. You have technical challenges. If there's a lot of documents, it can be hard for the witness, but you can make it work. And so I think what's happening right now is lawyers on the plaintiff side and on the defense side are just adapting, trying to figure out how are we going to still have these cases move along, because we know there's going to be delays getting trial dates. There already were, and now it's going to be quite a bit worse. How do we just keep our files moving so that we can get to the point where we can book a trial date, so that we're at least in line? And so I think everybody's trying to manage that, and we're all working together, plaintiff's counsel, defense counsel, to try to move things along.
Do you think some of this will stick, the new way of doing things, the video conferences and the Zoom questioning?
I think so. And I think, I'm more open to doing witness meetings by Zoom than I would have been before. Like, I was very much, if I'm prepping a nurse for a questioning, I'd want them face to face. I still want that, but in this environment, I'm not going to insist on that. It's not, for their safety or my safety. I view right now health providers as a very cherished commodity, right? Because one of the issues that we're going to have if COVID keeps going the way it is not a lack of beds. It's going to be a lack of healthcare providers, right? We're not going to have people to staff units. People are going to be sick or isolating. And so I don't want to be the cause of any person being taken out of circulation. So yeah. I'm absolutely willing to be flexible and be creative and get with the times. So that's what we've been doing.
Oh, good. Well, congratulations on that. I think it's been a big pivot in direction for a lot of people. But I'm always interested to ask that question. What if this is going to stick? What practices are you going to hang on to? Because I certainly know my year included 8 conferences across the country, which of course, none of them happened. But adapting with podcasts and webinars and, larger Zoom meetings. I think there's parts of this that I think we've been forced to find ways to use, which I think, we're going to hang on to. And any changes within the delivery of healthcare itself? I mean, I recently had a phone appointment with my doctor a couple of weeks ago, and she hated it. She said basically what you said. I like the face-to-face. I need the hands-on in order to do a really good diagnostic examination. But I mean, for me, with the particular problem that I had that day, I loved it. I just loved it. It took me 15 minutes versus 2.5 hours to go and sit and wait and see her and then drive and park and everything else. So are you noticing, or do you anticipate changes in the delivery of the institutional healthcare?
I think so. They've been working on telehealth and robotics for remote communities and that kind of thing. And I think just by being forced to embrace it as a result of COVID, I think people will be less resistant to it. Doing at least preliminary assessments by phone, triage type screening kind of meetings with patients in remote communities, or just frankly, even in the city, just to protect people from having to interact as much. So I could definitely see it sticking that way and freeing up the actual in-person seats in the waiting room or beds in the hospital for people that really need it. I do find it interesting, and I think one of the things that I'm sort of looking for in the future or arising out of COVID is, are there going to be cases where health providers will be criticized for a delay in diagnosis or an erroneous diagnosis because of doing a Zoom assessment as opposed to having the patient in person? Depending on the nature of the condition, you can't substitute, a palpation of the abdomen or something like that by Zoom. So I'll be interested to see if there is an attempt to hold physicians or other health providers to account for failing to actually do an in-person physical assessment. Exactly,
because those benefits will also bring challenges, which may also bring legal cases in the future, especially those things missed and delayed diagnosis due to, incomplete examination. So what, as knowing of myself as a nurse and working in obstetrics and high-risk obstetrics for much of my life, and I was always scared to death of a lawsuit, to be honest. And I was named in a lawsuit when I was a very young nurse. And the case settled very quickly. It was an issue of communication on a postpartum unit. And luckily, and I didn't even know it had gone on until the hospital lawyer came to talk to me after the fact. But, and said it had settled and sorted itself out and I was named, but don't worry about it, it was over. But it was still scary. Even after the fact, it was scary to me. But it also changed the trajectory of my career a little bit and opened my eyes that the possibility was there. But true confession, I've also been involved in quite a few cases where I was there and there were bad outcomes. And the advice to me at the time by the nursing union was to write everything down in great detail and put it in an envelope and mail it to myself and keep it in my drawer for the rest of my life. So, Mike, I have one of those. It's true. And I think it's likely beyond the statute of limitations, but it was an obstetrical case, so you don't know. I mean, it could show up forever, but the fact of the matter is that nurses are scared to death of litigation. And, I love how you just said, am I going to lose my house? Am I going to lose my job? Am I going to be in the front page of the paper? And certainly that happens sometimes, depending if these cases go very public. But what reassurance can you offer to any nurse who just doesn't understand or hasn't to this until they've heard you talk today, your job and your role? How do you reassure nurses that they're going to get through this okay, not lose their house and their car and hopefully not their marriage, because it's a situation that we're all petrified of. And I happen to know too that sometimes just being named as a defendant takes some nurses out of nursing. And, bright, shiny nurses and mid-career nurses and older nurses, this experience is stressful enough that I've met several who've either left nursing altogether or retired early or on extended health leave or just moved to a less risky area of healthcare, moved out of a hospital and into a clinic or something like that. So reassure us all a little bit to the best of your ability.
Yeah, well, I find it's interesting to hear you talk about the mailing something, because it's something that I hear about quite often. I've received them, and I remember not that long ago, maybe last year, a nurse came in and she had done that with respect to a particular case, and she brought it with her and she was sort of holding on to it very tightly, and I said, okay, well, can I look at it? And she's like, well, you're not going to open it, are you? And I'm like, yeah, I'm going to open it. She's like, well, but they told me you're not allowed to. And I'm like, so then I had to go through the explanation that I'm her lawyer and this is what this is for, and it's a note that you wrote to yourself. It's important, but the look on her face when I ripped open that envelope, I thought I was stabbing her or something. Right? She was just petrified because this had been sort of ingrained in her that somehow that this was so important, and that I was, she kind of didn't trust that I knew what I was talking about when I went to open it.
So what's going to happen in that note, Mike? Tell me from my own personal, knowledge, but also for everybody else listening in, what happens in that case? Because that is the advice I was given by the union at that time. So
in the vast majority of circumstances, that's a privileged document, and it's not going to be produced to the other side because it was written in contemplation of litigation. So, but what it turns on is why it was written. So, if the nurse says, well, this was a bad incident and I knew there might be a lawsuit, and so I went, and a lawyer told me when I did a seminar in nursing school that I should do this because I might get sued. The law of privilege is that if it's in contemplation of litigation, that it's a protected document. Sometimes the nurses will say, well, I just went home and wrote it down because I just wanted to make sure I had everything straight in my head. And in some circumstances, I produced those documents to plaintiff's counsel because they weren't sufficiently protected.
Mm-hmm. In what cases aren't they sufficiently protected?
In circumstances where the nurse can't say the reason they did it was because they thought they weren't going to get sued, or words to that effect.
Oh, I see.
In order for it to be protected and not producible to plaintiffs,
okay.
The reason for writing the document needs to be, I'm thinking I might get sued, or there might be a lawsuit, or there might be some sort of proceeding after the fact. Mm. The reason for doing it is to get your story down so that you can protect yourself from some sort of legal proceeding.
Ooh, I'm just going to file that away in my head right now.
There are no magic words that you have to say, and there's no incantation that has to be done.
But some version of that.
What is the primary purpose of writing the document? And right. If the primary purpose was related to a legal proceeding, then it's a privileged document.
Oh, I see. Okay. And I don't have concerns about this case. I mean, I just want to say that. But I was there, and there was a horrible outcome. So I thought the day, if it happens, my name's all over the chart, and I would be, now that I know what I know about litigation, I happen to know that I would be pulled into it for one reason or another. So.
Well, if it's more than 21 years ago, I think you're probably good. But if it's not, then keep it in your dresser drawer for a little while longer.
Okay, I will.
But as far as reassuring nurses, we spend a lot of time, and some nurses are reassurable and some really aren't. And I hate to hear you say that you know people who have left nursing because of it, but I do as well. I've had nurses who've been involved in cases that I've worked on. And frankly, some of the cases actually went really well, from the perspective of the defense of the case. And ultimately, in one example, the case, the plaintiffs went away. They just decided they couldn't prove their case. But in that one circumstance, a nurse still was traumatized enough that she left. She didn't leave nursing altogether. She went to work with HealthLink or something like that. And others have quit. Others have, as you said, moved to doctors' offices and that kind of thing. And, at the end of the day, all we can do is try to reassure people as much as we can. And we support people every step of the way. We prepare them for what is coming. The biggest issue in civil litigation is the questioning phase. And that's the part that's most stressful. And so what I always tell people is, put your nursing armor on. So you're a professional, you work in a hospital, you deal with difficult doctors, you deal with difficult patients, you deal with difficult other nurses. You are professional, you don't break down in the middle of your shift, you get through it, you might go have a glass of wine or cry or whatever when you get home, but you're professional. And so I always tell people when they come into questioning, put that nursing armor on. This is your role. You're here as a professional. You're here to answer questions that are legitimate questions. The plaintiffs have a right to seek compensation. And, let's just get through that. And then once you're through that, in the vast majority of our cases, that's it for the nurse. They may still stew about it. They may still feel concerned about it as it goes along. But the vast majority of cases don't actually go to trial. The next step for them would be actually having to testify at trial, but that happens very rarely. And so I just try to encourage them, let me worry about it. Let me do my job. I'll keep you posted as much as you want to be updated on the case. But once we get through questioning, put it behind you. At some point, you'll get a letter from me saying it's done. And, like I say, that works in some cases, and in other cases, it doesn't. For nurses who do really well or who handle it quite well, I'm mining for experts. So I'll say to them, look, I thought you did really well, and would you be interested in doing some expert work? And so you kind of have the two extremes. There are nurses who were nervous going through it and was upsetting and traumatic, etc. But then they recognize the importance of having good nursing experts who understand what it's like to actually practice in hospitals, as opposed to sitting from on high, from an academic institution criticizing nurses. So I think it's, you can have both outcomes. And I've had nursing people who I now use it as experts who have been prior defendants. And unfortunately, I've had people who have left nursing.
Yeah. I really appreciate, how you tell nurses to armor up, because I think, most nurses have that in them without a doubt. But I think a big understanding for me is also something like, just as a nurse and over time, and I'm proud/embarrassed to say I just got my congratulations on 40 years of nursing certificate last year. And I was like, how did that happen? But one of the things I learned over time was that malpractice exists to compensate clients who have been injured at the hands of healthcare providers. Whereas I think there's just a general feeling that malpractice exists to make, healthcare providers' lives miserable, and it's scary and it's a big unknown. So that understanding alone, that it's there, and that belief and understanding, and I don't think there's anybody who wouldn't agree with that when someone truly has been injured by no fault of their own, by, negligence or however you want to call it, by healthcare providers, that we would all want to be compensated for that if it was available. So I think that's a really good point. Well, I feel like I could talk to you about this for ever and ever, but, we've been chatting for quite a while. But before we end up, and I want to say thanks, I've told you this before, and I'm going to tell you again. I love your voice, and I love listening to your voice. And I could just sit here all day and just listen to you talk. It feels very soothing and relaxing and calming and insightful and informative all at the same time. But because the podcast listeners include doctors and nurses and lawyers and the general public, I want to ask you a couple of questions. I'd ask you to answer a question for each one of those audiences. In your view, as a hospital defense lawyer, what's the most valuable thing that the general public need to know about preventing nursing negligence or negligence? But I'm going to say nursing negligence because you most often defend nurses. What advice do you have to offer the public?
Well, I guess I would have a comment and then some advice. The comment that I would have is similar to what you said earlier, is that no one on the health provider side goes into this intending to cause harm to anyone. Everybody is doing the best they possibly can. And I think sometimes either plaintiffs or plaintiffs' counsel or even the nurses involved feel that litigation is about battle, and it becomes emotional and it becomes really adversarial. And that's not what it's meant to be. It is the system set up to provide victims of negligence with compensation. And sometimes in my conversations with nurses who are, really taking it personally, and really sometimes they'll lash out at the plaintiffs because they're taking it so personally. And sometimes I really have to snap their head back a little bit and say, wait a minute, like these people were harmed. They had an adverse outcome. Whether it was caused by someone's negligence or not is something we have to determine. But they have every right to bring this statement of claim or bring this litigation and seek compensation. And we're not here to judge that decision. What we're here to do is determine whether or not everyone met the standard of care, and if not, then make sure that people get reasonable compensation. As far as what the general public should know, I think I hesitate to talk about advocating for yourself, because I think there can be a real downside to that.
What's the downside?
I think because it can create an adversarial relationship immediately upon entering in the hospital, and if you're pushing too hard, if you're, I always say about myself, a little knowledge is a dangerous thing, right? So people have some symptoms, or they know they have a preliminary diagnosis, and they go consult Dr. Google, and then they're really pushing hard because everybody tells them that's what they have to do. It can become a barrier, and I've seen this in cases where the rapport and relationship between the patients and the health providers breaks down early on because people are being too aggressive. So I guess what I would say is you do have to advocate for yourself, in that you have to be informed. Take notes. Bring a pad of paper. Like, I've had, unfortunately, quite a bit of interactions with the healthcare system in my personal life. My brother was diagnosed with glioblastoma and passed away a year and a half later from a brain tumor. My father passed away last February. My wife has leukemia. So I've had my share of sitting in as a support person. Thankfully, I'm healthy, but as sitting in as a support person in doctors' meetings, and I'm there to take notes, right? I write down what's said, because often as the patient, you don't hear it. You're upset, you're elevated, you're scared. And so having somebody there with you, just taking some notes, and not again in an adversarial way with the doctor, but just trying to keep it straight so you can go have a conversation at the kitchen table later on when you're a little more calm and talk about, okay, well, what did the doctor say? Mm-hmm. So I think, making sure you advocate for yourself, keeping notes, and making sure you try to maintain a rapport with the health providers can go a long way, because it's a human system. Mm-hmm. And if you have a good relationship with people, things will probably go better for you.
That's a really good point, and I agree with you. There is an art to advocacy, without a doubt. And I just want to make a comment that the people in your life are lucky to have you. as their advocate at this point. So
it can be a downside, when both of my boys were born and we were in the labor and delivery room, I was looking at the strip coming out of the machine, and I was asking about D-cells, and people were looking at me like rolling their eyes like, oh my God. So, it can be a barrier at times, but
I'll tell you 100%, the doctors and nurses looking after your wife were petrified all day. I know that from behind the scenes. But anyway, thanks for those awesome and very insightful comments. And I think great advice. What about, what advice do you have for nurses to avoid litigation?
I think we talked about documentation earlier. It's an obvious one, making sure you're documenting the important things. I also think stepping out of the hierarchical structure of the healthcare system. The healthcare system has gone a long way to improving its hierarchical structure. I did my master's in law in 2005, 2006, and what I was focused on is patient safety and incidents of healthcare error. And one of the things that was a big part of the literature then was in aviation, how they'd made great strides in safety because they got rid of this hierarchical structure in the cockpit, where the co-pilot who was more junior would be afraid to speak up if they saw something that was going wrong. And, there were crashes that occurred where they felt largely that was the reason. And I think as between doctors, that's a problem. And that's advice I would give to doctors. As a resident, there are times when you should be speaking out and you choose not to. You have to choose to. You have to choose to speak out and trust that, the consequences will be what they will be, but they won't be unreasonable. And for nurses, it's the same thing, like being willing to advocate for your patient, being willing to advocate for yourself if you feel that things aren't going the way you think they should. And there's a chain of command. You can go to a charge nurse or your manager. If you need to, you can go over the head of the physician you're working with and go to another physician or a specialist. You don't do that in every case, but when you feel like you should be doing that, then you really should be doing that. I think that's one thing that I see where, in retrospect, reviewing a case or reviewing a chart, you can kind of see things going in a certain direction, and there were opportunities for residents or other physicians or nurses or others to have raised an alarm bell, and they didn't. And so I think that's a key. Don't just go along with a practice or policy or a culture in a unit. You've got an obligation to your patient. You've got a professional obligation to look out for your patient. So sometimes that means doing something that's uncomfortable. Yeah,
that's true. I see that in a lot of cases as well. There's a moment where something could have been said or done, and it wasn't done. But what advice do you have for the nurse or the doctor, the resident in that moment? I mean, it takes a lot of courage, and that's what nurses will often tell me. I can't do that. I mean, I don't have the courage to do that. No one will listen to me if I do speak up. Any advice for finding the fortitude that it takes in that moment to say what needs to be said?
Yeah, I mean, everybody has their own strengths and weaknesses. I think what I would say is, if there's we keep talking about baby cases, that seems to be what's on my mind.
Yeah. It's always on my mind.
Yeah, you don't necessarily have to go to that obstetrician who has a reputation for being very difficult and for chewing people out and that kind of thing. You can go to your patient care manager, your charge nurse, but what you say matters. So going to them and equivocating or just kind of raising a concern but not really saying what you think needs to happen isn't sufficient. Like if you have a serious concern and you think, for example, their baby's in distress, or that the GP who's caring for the mom should consult obstetrics, or whatever the circumstances, you need to say it, and then you need to document it. And then I think you've discharged your duty as a nurse. Like at the end of the day, there are limits to the scope of practice. You don't have a legal obligation to set your hair on fire in the hospital, and you have a legal obligation to take reasonable steps to try to raise the question. And at the end of the day, a clinical decision will be made by someone else. But I think it's not enough to say, she wouldn't listen to me, or
Right.
I'm afraid to speak to that person. I think there are other ways to go about going about it, and then somebody who's with some more seniority can then approach that physician if you're not able to do it yourself.
Yeah, that's right. It's a difficult thing to understand, but I do remember as a younger nurse that was a big deal. And there's been, I could think back to many times of my career that I should have spoken up. I hope I never stayed silent in moments where it really mattered, but I certainly stayed silent in moments where I wish I hadn't. But I mean, as I got older, it seemed like doctors got younger and my knowledge got greater. So, you just develop a level of confidence and respect from the people that you work with. So it got easier and easier. But that comes up a lot when I talk to big groups of young nurses in particular. They're like, I'm too afraid, or the consequences of this. I just try to say the consequences of that are going to be so much worse to live with than having to sort out, a doctor who yells at you or won't speak to you for 3 days or whatever happens. So anyway, thanks for that. So, and another question, another audience for you to answer that question for is lawyers, and perhaps in this particular case, plaintiff lawyers. What would you like them to know about your role as a hospital defense lawyer and nursing negligence in general?
Well, I think it's to the people that do this work a lot. There's not much that I can tell them that they don't already know. I think what I would say is, you don't have to name every person under the sun that a healthcare organization is vicariously liable for the conduct of its employees. And so it makes everyone's lives miserable when you name a whole bunch of peripheral players that aren't necessary. So that's just one issue that I deal with fairly frequently, that is just an unnecessary delay. It's going to take longer for me to do my job. It's going to take longer for you to get your case heard if you overly complicate things. Focus on what's important. Doesn't mean that you can't question those people later if you feel it's necessary, because they're employees of the organization, but focus on the key players. I think for people who don't maybe do as much of it, I would just really urge a lot of thought before going down the road of medical malpractice cases. And what I talked about earlier, focusing on, just because there's an adverse outcome does not mean that there was negligence that caused that outcome. And unfortunately, for people who don't do a lot of this work, we'll get right through to questioning, and the plaintiff's lawyer will be sort of aghast that their people would defend, but the person is blind, or but the person lost their leg, or but the person, whatever it is, that doesn't mean that somebody did something wrong, or that they didn't do their best. And it's just an inevitable result of their underlying condition. And so talk to experts early, preferably before you file your statement of claim, and make sure, because you're taking a big financial risk. Like it's not for the faint of heart. Plaintiffs' counsel do a great service to our society and our legal system by taking these files on contingencies where people couldn't pay for fee for service. And it's a high risk enterprise. So I just make sure that before you go down that road, that there's something there, and that it's not just a result of an underlying condition.
Yeah, that's a great response.
And the only thing I would add to that is also what you touched on earlier, which is looking across the table at a nurse or a doctor at questioning. Give them the professional respect that they're entitled to. That personal attacks or overly personal style of questioning, focusing on the sort of the dramatic impact of the plaintiffs is not fair to the witnesses. The witness should be treated with respect. They went to school. They are doing their best, even if they perhaps made a mistake. it's not because they intended to, it's because they were doing their best and they made a mistake. All of us are human. And I just think a little more from some plaintiffs' counsel, they could use a little more respect for the professionalism of the healthcare providers.
It's interesting that you bring that up because I'm just prepping a presentation for a Provincial Trial Lawyers Association next week. And it's on that exact topic about questioning doctors and nurses. And what we touched on just briefly earlier, that, that they're sitting there in one of the worst moments for many doctors and nurses. They're sitting there at one of the worst moments of their life and being drug, a spotlight just shone right on an error that they've made. And what they're really feeling is shameful, that can come across as anger or belligerence or tear or hurt. But it's really shame. And I'd be interested in your reaction to that, I guess. And I'm very interested after this, and I'm pulling in a psychologist to talk about if what you're looking at looks like belligerence, but it's belligerence posing as shame. How can a lawyer alter their own approach to that doctor or nurse to get to the facts, right? To get to the best of it, to calm the situation to the point that they can talk, or that they will talk openly and frankly about what's going on. So your comment on that and how you think it could perhaps maybe calm the situation.
Yeah, I think, I don't want to give too many state secrets away to plaintiffs' counsel, but what I would say to them is you're much more likely to get the evidence that you want to get if you treat people with respect, if you're affable, if you are genuine, if you are kind, ask questions. I mean, there's going to be tough questions, and everybody has to ask them. That's our system.
It's a terrible situation all the way around, isn't it?
Yeah, but the way you ask the question and your approach to people and your demeanor can make a huge difference in the responses that you get. So in my experience, it's pretty rare for the health provider to, I'll sound like a schoolyard kid, to start it, right, with belligerence. Most often they're reacting to the manner of the plaintiff's counsel, who feel that they need to really push hard or be aggressive in their questioning in order to do their job. And the best plaintiff's counsel, the ones that get the best evidence of questioning, much to my chagrin, are the ones that are affable and are genuine and are put people at ease and just have a conversation. And so I think ultimately that ends up being best for both sides, that it's not a traumatizing experience for the health provider, but better yet for plaintiffs, it actually helps your case. There are some exceptions to that. I'll pick on doctors a little bit. Yeah, there are some doctors out there who walk into questioning with a chip on their shoulder and right away from the beginning, they're wanting to spar with plaintiff's counsel. And then that's plaintiff's counsel have to do what they need to do in order to deal with that. But certainly from the nursing perspective, it's really rare. To the extent they get belligerent or defensive or shut down, it's generally because they've been approached in a way that wasn't productive.
Right. That's good. Thanks for that, Mike. That's really good. And I think probably really great advice all the way around, So I think with that, we'll close this off. Unless, is there anything else you'd like to say or anything else that you'd like the audience to know about your role? We're going to talk about you as a person in a few minutes in another podcast, but is there anything else you'd like to say?
I just think I would reemphasize what I said earlier, that this system may feel like it's set up to favor defendants, and there certainly are some structural issues, but there's good reason for it. The plaintiffs have to prove their case. They've got to prove that somebody departed culpably from the standard of care, and that breach caused their injury, because people in medical cases have underlying conditions. But what I'd also say is people are entitled to representation. They're entitled to bring their claims for compensation. And there are too often, I think, legitimate claims go unprosecuted because they're simply not worth enough, or the plaintiffs just don't have it in them emotionally. And I think that's a problem. for our society, because if people are going without compensation who legitimately need it for their future care, and that compensation would be forthcoming if they were only able to find a lawyer to take their case, I think that's something that we need to address in the system, because, people should get compensation that they're entitled to. And my job is just to make sure that happens, and the flip side is to make sure that people don't get compensation if they're not entitled to it.
Good one. I think that would be like a fascinating subject for a podcast in the future, is the huge variance in what research has shown are avoidable medical errors that cause serious injury, harm, or death, versus the number of those medical and or nursing errors that find their way into a medical malpractice lawsuit. I think it's less than 1%, if you believe the stats as they are. And the barriers to that, I often ask that question to lawyers and to groups of nurses. I have 5 people in my life that I could say probably had a legitimate malpractice lawsuit, but didn't pursue it for one reason or another. Often because they liked their doctor, or they liked the nurse, or they were just scared, or they thought it would cost them more money than they had in the bank to even launch a lawsuit. A lot of misconceptions. But I think that would be another great thing to talk about one day. Anyway, let's wrap this up. And I just want to say thanks so much. It's been an absolute pleasure talking to you and listening to you. I've learned a lot, and I have so appreciated what I see as a very fair and even judgment of the whole situation. So thank you very much for that.
Thank you.
Okay, let's wrap this up, and we'll be back for another one.
Sounds good.